Hello, my name is Jeff Gottlieb. I'm an attorney located in Southern California. Most of my practice, nearly all of it, involves children with disabilities. Most of my practice involves what's called IP and regional center matters. However, a significant part of my practice also involves divorce matters where a disabled child is involved. Most often that is an autistic child, but it doesn't have to be. It could be a child with any severe disability. Now, what I'd like to do is inform you, educate you today about two significant issues where there's a divorce and a disabled child is involved. The first issue is what's called legal custody. The second issue is what's called child support. Now, child support is all about money, but we're going to talk about that in a few more minutes. But what I'd first like to talk about is legal custody. Legal custody is about decision making. Give you some examples. It may be decision making in regards to medical matters. It may be decision making about educational matters. I think an example would probably help clarify this significantly. Most of you, I assume, are familiar with what's called an IEP, so I'm not going to explain that today. But basically, it's where the school district makes an offer of placement and services. Placement may be in a special day class. It may be in mainstream. It may involve an aide, one-to-one aide, a shadow aide. It may involve occupational therapy, physical therapy, speech therapy, etc. Well, what happens when the school district makes an offer, but one parent wants to accept that offer, but the other parent wants to reject it? Well, that puts the school district in a difficult situation. The school district may simply contend that if both parents cannot agree, and there's what's called joint legal custody, which I'll explain in a moment, that there's no decision. That is a problem. That is probably the best example I could give you where sole legal custody becomes necessary as distinct from joint legal custody. So let me explain to you what joint legal custody is. That takes place most often in a situation where the parents are going through a divorce and the children are not disabled, which is most cases. In that situation, the court will almost always award what's called joint legal custody. And that is where both parents have to agree as to decisions. So, for example, as to what school the child will attend, private, public, what pediatrician the child will go to. It may involve what pediatrician the child goes to. Those are decisions that once the divorce is over, most often, even if it's a contentious situation, the parents can make those decisions. But where there's a real problem is when there's a disabled child, just as I gave the example before with the IEP meeting. In that situation, joint legal custody is not working. So that would mean that there is a need for an order of what's called sole legal custody, where one parent makes that decision rather than both parents as to decisions involving medical and educational and similar matters. Now, when will that take place? Well, there's two types of orders. One is called temporary orders, and the other one is called permanent orders. Permanent orders are those orders that are made that happen at the time of judgment, when the case is final, or when there's a trial. Temporary orders are orders that take place typically after the petition for divorce is filed, but before a final judgment. Now, I want to make you aware, in California, a divorce can take anywhere from 6 months to a year, even a year and a half in some situations, most often close to a year. So you need orders in place where there is disagreement between the parents as to legal custody in regards to a disabled child. So what will take place is that after the petition for the divorce is filed for disillusionment of the marriage, you need to file what's called an OSC. An OSC is an order to show cause. It's a motion for temporary orders. So there may be an OSC, an order to show cause, for sole legal custody. So if you're the parent that wants sole legal custody as distinct from joint legal custody, in that order request of the OSC, you have to be persuasive to the court, to the judge. You have to convince the judge why you should have sole legal custody as distinct from joint legal custody, or your other spouse having sole legal custody. Now, how are you persuasive? One is you attach what's called a declaration. That is from you, perhaps. And that will explain to the court why you should have sole legal custody. You may explain that you and your husband have running disagreements, and because you have running disagreements, decisions cannot be made. Those decisions are important to the well-being of your child. Now, how do you prove that? Well, you have to explain to the judge, first of all, what is your child's disability. So if your child has autism, you have to explain to the court what autism is. Don't assume the court knows. Then you have to explain the nature of your conflict. And then you have to go into detail of where those disagreements have occurred and how they've affected your child. Now, you're going to explain that in your declaration. You may get a declaration from a psychologist who observed what's going on. You may get it from a therapist. You may have to have exhibits, probably will, attached to your declaration. You may have IEPs that show that you attended IEPs and your spouse did not attend. You may have assessments in there. You may have diagnosis from physicians. You may even have to call witnesses at an OSC hearing to explain to the judge what is going on. You need to be persuasive to the judge to convince the judge. One is that decisions cannot be made under the current situation and why you as a parent are a better person to make these decisions than the other spouse. Now, separate from that, there's the matter of what's called child support. Again, as I talked about earlier, child support is about money. Now, two things you need to know about California law, and we're only talking about California, by the way, today. One is that if you have a severely, significantly disabled child, typically child support will end when the child reaches maturity. However, in California, there's a case a number of years ago that if a child is significantly or severely disabled, child support can go beyond maturity and can go on until the child passes away or one of the parents passes away. So child support can last for decades in the situation involving a disabled child. So what do you need to do to get the most amount of money for you or to reduce child support to the other side? What you need to do if you want, for example, and I'll give that situation, where you want more child support from the other child other than what's provided otherwise by law, you have to demonstrate that your child has unique requirements and those unique requirements cost money. So, for example, if your child needs more ABA that's applied behavior analysis, than the school district provides or the regional center, you need to document that, but you're also going to need proof. Again, you're going to need either declarations from professionals who know your child to explain why your child needs more than the child is getting, let's say through insurance, through the regional center, or the school district. And then you're going to need to have those professionals explain why your child not only needs them, but the consequence of your child not receiving those additional services. It may be regression or a need for progression faster than is otherwise occurring. Now, how do you get that in? You get that into your OSC either by declaration or by people testifying at a hearing. Again, to summarize, on the child support, you need to state what are the additional services your child needs because of your child's unique requirements and why that will make a difference in your child's life. Again, to summarize, two basic issues that are important uniquely to divorce cases involving disabled children. One is legal custody, decision making, whether it's going to be joint or sole legal custody in terms of decision making, or some other decision where the court perhaps carves out part of legal custody. For example, the court may award joint legal custody, but for educational matters, one parent has that versus the other parent. The other thing that I've talked about is child support. And child support, to summarize, you need to be able to persuade the court, and everything is about being persuasive, of one, what are the additional requirements that your child needs more than the typical child, more than what the court would otherwise award, and how that will make a difference in your child's life and what it will cost. And you're definitely, in child support matters, going to require clinical expertise to be possibly present at a hearing to persuade the judge. Hopefully this has been helpful to you. If you have any questions and you're located in Southern California, please feel free to give me a call at 562-699-2412. That's 562-699-2412. Thank you very much and have a good day.